Ms. Deuce-McCoy, this is your client's motion, is that correct?
That is correct, Your Honor.
All right, and what are you looking to change?
We were asking the court to change the parties' joint physical and joint legal custody to primary physical custody with my client. The parties presently have a parenting time schedule, which is a little unusual, but they've had it since the entry of the order, which was 2 days on, 2 days off, and then 3 days. So 2, 2, 3 alternating overnights for the parties. So then they end up alternating weekends and having time with the child during the week. What we're asking for is every other weekend for the defendant because we feel that the minor child has struggled under this schedule. Since the entry of the order, she's been suspended from both school and the after-school program latchkey due to her behavioral problems, which have been things like throwing things and biting teachers and generally being disruptive in the classroom. The minor child does have Down syndrome. And she still is not yet potty trained. We feel that this is due in part to inconsistency between the households of the parties. The parties have pretty bad communication with each other, and they tend to disagree and not, I guess I would say it seems like they don't work together on most issues. My client has received the child in wet pants multiple times from the defendant. She feels that the work that she does in her home on the potty training goes well, that she's consistent with the school, and that the defendant simply doesn't want to do what they're doing and does something different, which is difficult for the child because she does require consistency given her special needs. The defendant also did not attend the 2024 IEP for the minor child. He doesn't provide sufficient supplies to the school, resulting in the school calling the plaintiff at work and her having to bring those items to the school. So frankly, for her consistency, we feel that it's best for her to have a regular schedule where she's going from one parent's home to school. Another problem is that the defendant resides in Lachine while my client resides in the Gaylord area where the child goes to school. And on those days when Lily has to go with her father to Lachine, she has to drive an hour there, has to drive an hour back in the morning. And so we feel that that's contributing to those behavioral problems as well. The parties also have had significant disagreement on their exchange time and their exchange location. The defendant has been insisting on a location that works best for him and has even told my client that he was going to make her life hard, essentially making it difficult for her. And we have proof of that, which we provided in both our motion and to opposing counsel. So we are asking for, again, for the child's consistency and for her best interest, that she have a regular and consistent schedule with my client.
I'm sorry, Judge. I thought you simply inquired of Ms. Deuce-McCoy what changes they wanted. I didn't know that we were going to go into a great litany of her perception of the behavior of the party. I take exception to that. This case is clearly in need of an evidentiary hearing. We would ask the court to set it for a 3-hour hearing, but I would ask the court to initially determine whether there's proper cause or change of circumstance. These people have been divorced for less than a year, and she's already seeking to change custody. It's just inappropriate and not necessary. So I think an evidentiary hearing is what we all need.
All right, we can set that for an evidentiary hearing. My first available 3-hour slot is March 4th at 1 p.m.
I know that I have a conflict with that date, Your Honor.
All right, and March 18th at 1 p.m.
Let me just see if I could have a moment.
That date works for my schedule.
I am also available.
Okay, so we'll give you guys March 18th at 1 p.m. 3 hours. Parties do need to file a witness and exhibit list 14 days prior. I know the child is 8. You did mention the special needs. Do the parties think an interview is appropriate or not appropriate?
I don't believe that she would be able to state a preference, Your Honor.
We agree with that, Judge. We don't think she would.
All right, so given that information from the attorneys, we will not require a preference interview in this matter. All right, thank you both for appearing. We'll see you back here March 18th.
Thank you.
Call the matter of Carolyn Tabby versus Adrian Wright, file number 98-7754 DP. Do we have anyone present on that matter? All right, if your name gets called, you need to let me know that you're here.
I'm here.
Thank you. For the court, what is the status of this matter?
This matter was adjourned from October 15th to allow a friend of the court to register the case with Canada and try to verify the plaintiff's employment. She was failed to appear at that hearing. Prior to that, however, she did sign a stipulated order on June 20th, 2025, agreeing to pay $500 per month and that she would appear July 16th, which she did do. The payment, it's arrears only. Current balance on the case is $20,101.40, with the last payment received in August in the amount of $25.
Thank you. Ma'am, what would you like to say?
I just moved to Canada in July, and I am not able to get a work permit due to all the people from the US are leaving the United States to come to Canada. And that has put a big load on the immigration. So I'm not able to get a work permit until I get married. And I plan on getting married sometime in mid-February. And I just recently paid $3,200. And that's equivalent to about $5,200 Canadian. I just paid that.
All right. When did you make that payment?
I believe it was like a week ago.
All right. Was that an online payment or did you mail payment?
Yes, online through MISDU.
Okay.
It's 3,500.
In front of the court, you don't have that information
That
yet.
hasn't been
All right.
reflected yet, no.
Sometimes obviously there's a lag in information, but I'm going to take you at your word. I'm going to adjourn you out a little bit then to see just to make sure that payment happened and see what else you're able to do. And then also get the update, I guess, on the employment. I'm going to adjourn you to March 11th, which will give you a little bit more time to see where you're at, okay?
Okay, until then, how would I go about getting it, what do you call it? To get the payments lowered until I am able to get my work permit.
Is there a set monthly payment right now?
Well, the
She do
stip
whatever
that she
request.
signed
Oh, yeah.
agreed to $500 a month.
Okay. Yeah, ma'am, you'd have to file a motion to do that.
Okay, and how would I do that?
You can contact the front of the court office. They'll give you they can let you know where the paperwork can be found and help you with that, as well as give you a court date, okay?
Okay, thank you.
All right, thank you for appearing. You're all set.
Thank you.
We're next call the matter of Nicole Nuttall versus Angel Padro Jr., file number 99-8322DS. Do we have anyone present on that matter? Looks like we have Mr. Padro looking to unmute himself, so keep trying, sir.
Hello?
All right,
Hello?
I can hear you now, sir. Thank you. Yes, I hear you. In front of the court, what is the status of this matter?
This matter is an arrears only case, and the defendant signed a stip order with us on December 22nd, agreeing to pay $100 a month and to keep in contact with our office if he was going to be late or unable to pay, and that he was to report any new employment and then appear today. The balance on the case is $1,470.44, with the last payment being received in December in the amount of $300.
All right, thank you. Sir, what would you like to say?
I started employment with H&H on well, I had my drug screen Monday here, and then the H&H would be in Vanderbilt, but I don't even really owe that much for you guys to even be bothering me like this.
Oh, well, I'm sorry to inconvenience you, sir, but you do need to make sure your payments are coming in. If you're making your payments, you won't have to keep coming before me, but the issue is that obviously you fell behind. You're free certainly to pay the entire thing off, and then you would have no need to come in since it is not a charging matter. But right now it appears that you have an agreement to pay at least $100 a month. Is that correct?
Yes, what she told me I had to pay. I mean, it wasn't an agreement.
Okay. Yes, you are required to pay at least $100. As I indicated, if you don't want to have to deal with the court, you can pay the whole thing off and then it would just be done. But until that is done, you need to make sure you're paying at least $100 per month.
Is Nicole present too? The other half of this party?
I did not hear her identify herself for the record, so it does not appear so.
Does she
All right,
get
so
a
any
show
issue?
cause?
No, sir, she's not. Her appearance is technically voluntarily since she is not facing back support at this time.
All
If she
right.
wants to come here and make comments, she's certainly free to do so. But the party who's not doing anything wrong would not be held in contempt for failing to appear.
Now, since I do have employment now, and you guys are just going to be garnishing my wages, I don't think I'll be able to pay the full $100, due to other circumstances that I'm having right now. So, but you guys will be able to get your.
You put income withholding?
This is the first that I've heard that he's working at H&H. He was supposed to call and notify me once that was secured.
All right. How long have you been there, sir?
I haven't been there. I do my drug screening on Monday. I just
Okay,
got
that's right.
called yesterday for this job.
All right. So yeah, if you pass all that and get the job, let the front of the court caseworker know. She can prepare the withholding order, which will take out, it'll be $100 for the month. So it'll be divided up over your paychecks, depending on how you're paid. And then you wouldn't have to pay anything else directly to the court. You're certainly free to pay more, and then because obviously the sooner you pay everything off, the sooner you don't have to worry about appearing for court and having money coming out of your paycheck. But we're not going to take out more because we've come to an agreement that it would be, as long as you're paying $100 a month, we're okay.
All right. Would there be any way I could just get the jail time and do work release?
Well, if you decide that you're not going to make payments, then we'll bring you in and we'll have a contempt hearing. I'm not going to offer that as an option to you now. If you fail to make payments, then we're certainly going to have a discussion on what we do next.
I mean, how many days in jail would it be just to finish off this $1,000 that I owe?
Well, contempt is ongoing, so I can't tell you what you would get, and it would be Judge Hesselink that determines what he does with you if you do not make payments. All right, so I'm going to adjourn your case out since you've got employment, just to make sure things are happening. We're going to adjourn to March 11th. However, if there's an income withholding order in place and payments are coming in, you would not have to appear that day. But if you're not meeting your payments, you would. And then additionally, so until money's coming out of your check, if you do get paid, you have to make that payment directly. Do you understand that?
Yes.
Okay. All right. Thank you for appearing, sir. You're all set for today.
Thank
We're here on a status conference. The parties were before the court previously. We adjourned out as they were going to work on a specific schedule, I believe, for parenting time in 2026. So, Ms. Speaker, have the parties reached an agreement?
Yes, we did. He wrote them down when he brought Anya back from Christmas break that she spent a few days with him.
Okay.
We have, did you want me to go through and just list them off for you?
Sure.
Okay, January, he picked the dates of the 16th through the 18th. February, he picked the 20th through the 22nd. March, he picked the 20th through the 22nd. April, he picked the 17th through the 19th. May, the 15th through the 17th. June, he said the 19th through the 21st. It's Father's Day weekend, I'm sorry. July, the 17th through the 19th. And August, the 21st through the 23rd.
Which is generally every third weekend.
Okay. And then what about the rest of the year? Is that something you guys are addressing later, or what's the situation there?
I'm assuming that we're going to address it later with the situation, but I'm assuming I think what we came upon in the agreement, he's going to shoot for the third weekend of every month.
Okay. So it'll continue throughout the year to be 1 weekend a month.
Yes. But as of right now, that's the dates that he wrote down and that we do have that we can give to you.
Okay. And you guys have an agreement as to when that parenting time starts and when that parenting time ends?
It'll start or those dates of Friday, I'm assuming, Brandon.
What time of day?
I would like it done by 5 o'clock, no later, especially if we're meeting, because I need to be home and I have a son as well that I have to make sure is in bed and everything else. And I also don't like driving at night at all.
All right, sir, are you in agreement with exchanges at 5 p.m.?
Yeah, yep.
Okay, and where do you guys make the exchange at? Do you meet somewhere? Does one of you go to the other person's house? What's the plan there?
Nope, we meet usually in a public place.
Generally, I
Alright.
go up to Gaylord though.
Yep.
All right, so where do we want to say you're meeting at?
Would you like to just stick with coming up to Gaylord with her, Brandon, so that way you can know that you'll be with her here?
With all due respect, no, because I don't have any ties or anything like that to Gaylord whatsoever. My closest ties to connections is Osceola County and or Macomb County. So if we can arrange meeting even somewhere along like Houghton Lake area, that would
And
be
Lake works
perfect.
perfect for me. Yes.
Then that would be perfect, and I can do what I need from there.
And that's a lot closer than other times. So yes, thank you. And I appreciate that.
So what place in Houghton Lake?
At more than likely a gas station, a public
the-
place that has,
Or the Super 8 Hotel, which is right off I-75. Yeah.
All right, you okay with that, ma'am?
yeah, I always have someone with me when I exchange her.
All right, so we'll say the parking lot at the Super 8 in Houghton Lake, correct?
Yep.
Okay. All right, any other terms regarding the parenting time?
That she stays on her routine for school and bed. She is only 5. She does not need to be up until 11 o'clock midnight running around at all hours and then drop back off to me to start her school week, to where she has to get up at 5:30, 6 o'clock in the morning for school week. So I just would like her bedtime routine to stick around what it is, which is she's usually in bed and laying down by no later than 9 o'clock.
So as to legal custody, is there an agreement regarding whether legal custody is joint or sole to one of you?
I mean, I have her all the time, all of her doctor's appointments.
Physical
I take
custody,
her
so
to,
do you guys have any agreement as to legal custody?
I think he just didn't want his rights taken away. He wanted to be able to have his time with her.
All right, let me try it this way. Are you guys agreeing to joint legal custody, or is one of you having the sole legal custody?
I would like sole legal custody of her.
Sir, are you in agreement or disagreement with that?
For the moment, due to my situation in life, I am in agreement.
All right, so you understand, sir, the difference between legal and physical custody? So there's 2 separate standards. Physical custody, obviously based on this agreement, she's going to have the primary physical custody. Legal custody is different. Legal custody relates to the parties having joint decision-making when it comes to important things affecting the child, like medical decisions, medical procedures, schooling, taking medications, and those type of things. So are you agreeing, sir, that she would have the sole legal custody?
Yes, I would just ask that obviously she just brings it to my attention,
Which I always do. I
Of course, of
discussed
course.
all of her well-being with him.
Absolutely.
All right, so ma'am, I'm going to start with you. Would you please raise your right hand?
Yes,
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I solemnly swear yes.
All right, thank you. And you put your hand down, ma'am. Is it correct you're asking the court to enter an order that grants you sole legal and sole physical custody of the minor child, with Mr. Beaker having 1 weekend per month?
Yes,
And you're agreeing that you'll make exchanges at 5 p.m. on
Yes.
Fridays and Sundays in Houghton Lake at the parking lot for the Super 8?
yes,
And do you believe this agreement is in the best interest of your child?
I do.
The two of you have any agreement regarding any holidays, or is it just this pairing time that's been agreed to as far as 1 weekend a month?
Oh, no,
Happy.
I would be in agreement to him later with holidays. We always share holidays, even Christmas. I spent Christmas with her and he came up later that night to get her. And then he brought her back home later. So
All right, so holidays.
I would
you're
never
gonna-
want to keep her away from her dad.
You want to follow a specific holiday schedule, or just do it as the two of you agree?
Do it as the two of us agree.
Yes.
All right, Mr. Baker, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Are you asking the court to enter an order that grants Ms. Beaker the sole legal and sole physical custody of your minor child?
Yes.
And you would have parenting time 1 weekend a month, plus holidays as the parties agree, is that correct?
Yes.
And you will do exchanges in Houghton Lake at the Super 8 at 5 p.m., is that correct?
Yes, sir.
And do you believe this agreement is in the best interest of your child?
Absolutely.
Okay. So in front of the court, there was a recommendation. Has that become final yet or not?
It is not, it's still in the objection process.
Okay.
The court did indicate to utilize 10 overnights for the defendant.
All right, so obviously we have more than that, so we'd have to make that change. So it's 24 based on the 1 weekend, but then there's some, so for holidays, is it anticipated that he'll have some overnights during those holidays?
And it's anticipated, but not set in stone, to where those weekends too, if he has to, like change the weekend to where it's still a weekend, but it can't be that third weekend in the month, as long as he takes their 1 weekend a month, there is that.
What I'm trying to determine is whether or not we should add some additional overnights to that figure, or if it's really going to be 24, or with the holiday time, he might have an extra, 3 or 6 throughout the year. What are your thoughts on that?
What do you think, Brandon? Sometimes you're able to take her for a couple days more, and sometimes you're not.
So honestly, the way that I see and I feel about this situation is like I talked to you, Stephanie. Currently with my situation, not having a car, things like that. Let's keep that as it is. But like I had also discussed with you in the process of getting a car, getting my own home, getting my own everything. Once that gets all established, I figured and I'm hoping that we can arrange more times from there.
Yes, and I would be okay with that once you're established and on your feet.
All right, so for this particular moment, should I use 24 overnights for the year or something else?
24 would be fine,
Yep.
Your Honor.
You agree, Mr. Beaker? Okay, all right, so
Yes,
we'll prepare a
absolutely.
new round then based on 24 overnights.
With like effective beginning of this year then? 'Cause-
Yes.
Okay, so it's here, all right, thank you.
All right, and sir, you heard her list off those weekends. Those are the weekends that you've agreed to so far through August of this year, is that correct?
Yes, sir.
Okay. All right, we will prepare that paperwork. Anything else, Miss or Mr. Beaker?
Not that I have now.
Front of the court,
No,
any
you're-
questions?
Would it be possible if the parties could just potentially indicate to me if they have any objection information on the order that went out? Because what I could do is potentially do a second one as a tier,
Okay.
but I would just want to make sure that the information is correct.
And the two of you had a chance to look at that support recommendation that was sent out?
I have not received it yet. I've been picking up some midnight shifts at work to make up for the hours I haven't been getting during the day. And then I had a problem with my mailbox, but I have not received it as of yesterday morning. I have not received a letter yet.
All right, we're all set then for today. Again, that terms will be laid out into an order as well as a new support recommendation prepared. Thank you both for appearing. You're all set.
Thank you.
Thank you.
In front of the court, what is the status of this matter?
The defendant has a monthly obligation of $458 plus an additional $50 ordered on arrears. His balance is currently $27,150.49. Last payment received was in October in the amount of $150. I have had a conversation with Mr. Palmer regarding options that he could potentially explore to maybe lower the support amount, and we're going to have a meeting later today to discuss that further. He did have employment, however, recently lost his job and is not currently working.
Thank you. Sir, what would you like to say?
Just that times are really tough right at the moment. I recently, I guess it's going on 9 months now, I've had custody of my middle child, who's 11, and just wintertime's really hard without a license. I did have my job at the August house, but they happened to have to let me go because I'm a felon because of this case. So I'm put in applications all over Indian River. That's where I live. I have applications in at the gas stations and stuff, but it is winter and they're pretty slow this time of year. But I am trying.
All right, well, if you're behind 27,000, times have been tougher longer than recently.
Yes,
Very
no,
large balance, and there's been no payment in November or December. So when are we gonna see some money on this matter soon?
I'm hoping here like by the end of this month. I have our secondary vehicle on Marketplace right now trying to sell. It's been on there for a month now. And my wife just filed taxes as well, so when those come in, I plan on paying a pretty large amount to get caught up. Well, obviously I'm not going to be able to get caught up, but caught up from what I've missed since I got out of jail last year. I did really good for the first 8 months, and then just.
All right, I'm gonna adjourn you out about a month to February 11th. Give you a chance to make a good faith effort to get some money in. If you got no payment in, you can certainly expect that your case will get sent to the judge for a contempt hearing. And obviously, you can talk to your caseworker some more. I mean, perhaps you can reduce your monthly obligation, but that's not gonna reduce your back pay. So you need to.
Oh, yes, I understand that.
Prove and show a good effort to get employment, okay?
Yes, Your Honor.
All right, you're all set
Thank
today,
you.
sir.
Have a good day.
President, in front of the court, what is the status of this matter?
This matter has been adjourned from November 12th to continue to monitor the defendant's payments. This case is arrears only with a current balance of it's $3,549. His last payment was in December in the amount of $50, and he has been very good about staying in contact with us if he's going to be late or unable to make his full obligation. There was also a stip that was signed in September of 25 where he had agreed to pay $100 per week or contact us if he was going to be late or unable to pay.
All right, sir, what would you like to say?
I guess it work's just really slow right now. I mean, in the wintertime, we'd be lucky to get 20 hours of work. I'm just doing my best just to pay my bills at the moment. I mean, I don't know if we could get this adjourned for a couple months, and hopefully I'm pretty sure we'll be picking up by then.
Well, are you able to get, I'm expecting you to get some money in the meantime. You may not meet that full payment of $100 a week, but
Right. Yeah, I'll do my best. I'll do my best to get some in there this next couple weeks. I'm in Arizona right now. I brought my mom down here for my sister. Her daughter had a baby, so she wanted to come down and see it. And then I'll be back within the next couple days, and I'll get back to work. I'm gonna do my best.
Okay. I'm gonna reset you for I'm gonna go out to April 8th. So give you a good chunk of time to get payments in and show your progress, okay?
Thanks, sir.
All right, you're all set. In front of the court, what is the status of this matter?
This matter was adjourned from December 10th to monitor the defendant's payments. And you had advised him that if there were no payments, then contempt would be considered. His monthly obligation is $261 with a balance of $4,543.03. He does have an active income withholding, and in January so far, we've received $188.28, and in December, we received $664.84. It looks like the income withholding order is likely going to be meeting his obligation. We would be open to dismissing or adjourning.
Thank you. Mr. Barry, what would you like to say?
Just that my hours were cut considerably throughout the month of December, and last week they let me go from my job. So right now I have the onboarding packet done for Wendy's. They're just waiting on my background check, and I'll be starting a new job with Wendy's as soon as that comes through. But other than that, I made a payment manually of $100, and I didn't realize that you guys were already taking it out of my check. So as of right now, are we good, or do you need me to do something else right now?
No, I mean, certainly what we'll do is adjourn the matter out, just to make sure that the next job comes through and that we're collecting on it. So I'm going to adjourn you to March 4th. If you're officially hired, you got to make sure you let your caseworker know.
Yes.
And then obviously, typically pay attention to your paychecks, because usually the first paycheck or two will not have the money coming out. So if it's not coming out, you do have to make a payment until it starts getting deducted. Okay.
All right. Thank you, sir.
All right. You're all set. In front of the court, what is the status of this file?
The defendant has a support obligation of $365 plus an additional $148 ordered on arrears. He did do a stipulated order with us on November 24th, agreeing to meet his monthly obligation and to contact us if he was going to be late, short, etc. with his payment. And that appeared today. His current balance is $10,070.92, with the last payment received in this month in the amount of $25. Prior to that, it was in November in the amount of $616, which was part of the stip.
Thank you, sir. What would you like to say?
Just going through a tough time at the moment. Our power just got turned off yesterday. I have a couple applications out. I'm waiting for my background check for DoorDash and like smart delivery. I just made it, and it's not much, but I just made another $20 payment this morning. I've been doing mobile mechanic work when the opportunity presents itself. It's just not, it's not keeping me busy enough right now.
Okay, well, you're not certainly meeting the agreement that we made back in November. I'm going to give you one chance to try and get yourself back on track and adjourn you to February 11th. But if we don't have better news and better payments, then we'll send the matter back to the judge, okay?
Okay.
All right, you're all set. Let's call the matter of Katie Kirk versus Anthony Perez, file number 22-19023DS. Do you have anyone present on that? Not appear that either party is present. In front of the court, what is the status of this file?
The defendant has a monthly support obligation of $202, and this matter has been adjourned from November 5th to monitor the defendant's payments. as he had signed a stiff order with us on September 16th, agreeing to meet his monthly obligation and then appear in November, which he had done. Current balance on the account is $5,214.73, with the last payment being received in November in the amount of $57.46. I have not had any contact with him.
Thank you. His failure to appear, I will recommend a bench warrant amount of $1,325 plus $100 in costs. Next call is the matter of Shannon Susie versus Kayla Stantz, file number 23-19380DM. Do anyone present on that file? All right.
Here, Your Honor.
Thank you. And in front of the court, what is the status of this matter?
This matter was adjourned from November 5th to monitor the defendant's payments and to allow her the opportunity to bring in paperwork regarding that hearing, where she had stated that there had been an error on the notice. She has not made any additional payments or brought in that notice. Support obligation is $48 a month, and the current balance is $864. Last payment received was in August of 25 in the amount of $50.
Thank you, sir. Anything that you'd like to say?
Yes, Your Honor. Apparently she changed her address to my address, which she does not live at. She has left the state and went back to Georgia. She was supposed to return back in December to see the children for Christmas, and she refused. And I have, as a parent, told her that her visitations and everything will be postponed until she's able to keep to her words with the kids and contact her kids.
All right, thank you. Do you have an address for her?
No, I do not have an address for her. I can try to get one. I don't live down here in Georgia. I'm coming back to Michigan. And it's just been an ongoing battle with her, with lies and everything else.
All right, so if you do get any information, sir, that might be helpful to the front of the court as far as an address or employment, I just ask that you please call. But given her failure to appear today, I am going to recommend the bench warrant amount of $500 plus $100 in costs. Thank you for appearing, sir. You're all set.
Thank you.
We're next on the matter of Cassandra Guinea versus Greg Morgan, file number 24-19670DS. Do we have anyone present on that matter?
Yes, Your Honor.
All right, thank you. We have Mr. Morgan present.
I'm here too.
All right, thank you. Friend of the court, what is the status of this matter?
This matter was adjourned from December 10th to monitor the defendant's payments. You had requested that he pay $234 prior to December 31st, or the matter could be set before the judge for contempt. His support obligation is $134. Current balance on the case is $989, and the defendant did make a $250 payment yesterday. However, that is not reflected in the balance yet.
Thank you. Sir, what would you like to say?
Yes, Your Honor. When I was previously before you, I did not hear the stipulation that said before December 31st. I was under the impression it was by today. In the meanwhile, I did pay off all my responsibilities and obligations to get my license back. I'm just awaiting a road test. I still have a place. I'm still planning on making another payment before the end of the month. And like I said, I did not realize that stipulation of by the 31st of December was on there. And I apologize for that, Your Honor. My ignorance isn't an excuse, but it won't happen again.
All right, what do you think you can get in before this month is over?
Another 250.
You do the same for February?
Yep. I want to play. I mean, I might even. I'm going to say I'm going to shoot for 250. But if I can get more, I'm going to do more because I want to make sure that I get the caught up. And I'm just now getting my license back. I don't want arrears to mess up what I'm building here. So I definitely want to stay on top of this, and I don't want to lose something I'm fighting so hard to get back.
All right, thank you. Ma'am, anything that you'd like to say?
No, Your Honor.
All right, well, I mean, given that the payment did come in, it was the monthly amount plus extra. I am going to give you a chance, sir. I'm going to adjourn you to March 4th. If you make payments totaling at least $500, so 250, additional 250 for January and additional 250 for February. So an additional $500, if that's paid before that March 4th date, you would not have to appear. Any questions?
No, sir. Thank you very much for the opportunity.
All right, any questions, ma'am?
No.
All right, thank you both for appearing. You're all set.
Thank you. Have a good day.
Next call, the matter of Stephen McClure versus Emma Ballard, file number 24-19706DM. Do we have anyone present on that matter?
I'm here, Your Honor.
Thank you. In front of the court, what is the status of this file?
This matter was adjourned from November 12th to monitor the defendant's payments and income withholding order. She was failed to appear at that hearing. Her monthly obligation is $803 and the current balance is $5,917.77. It looks like the income withholding order is meeting and exceeding the monthly support obligation. So we would be willing to dismiss.
Thank you, sir. Anything you'd like to say?
Nope.
All right, well, given that we do have that income withholding order that is adequately collecting, I will recommend dismissal of the matter. Thank you for being here, sir. You're all set.
All right, thank you.
This is a status hearing after the two of you attended mediation. Did you reach any agreements?
Yes, on majority of it, except the co-parenting counseling.
Okay, is that correct, sir?
Yeah, for the most part, as far as the schooling goes, I kind of do have some disagreements on that, but we just weren't getting anywhere with the mediation, so just talk about that, I guess.
Well, let me just look at the paperwork and see what we can address. So, man, this came about based on your motion, is that correct?
Yes.
All right. And what do you feel then remain the outstanding issues at this time?
Well, we did agree on the schooling. He did agree on that in the mediation. So if he didn't agree with it, then he shouldn't have there. But the co-parenting counseling, I feel is needed. We can't communicate very well, or we just don't communicate at all. We need to have a good co-parenting relationship for our daughter. She needs to see that. Situations on both sides have been hostile to the point where in-person events don't go very well, and I'd like to get to that point with him, but due to things in the past that I've done wrong and he's done wrong, I would like to move on, but it just feels like he wants to live with things in the past rather than try and heal this relationship and try to move on from that.
Yeah, I do see the mediation agreement indicates that the child would attend Johannesburg schools.
Yes.
Was that your agreement that day, sir?
Yes, it was at that day, and then I thought, like, that just doesn't seem appropriate. It really doesn't. I mean, we're not even in a school district, and I felt like that mediation, we were not getting anywhere at all. We were just sitting there arguing for an hour and a half, and nothing was happening out of it. So yes, I did agree that day. However, I feel that is not appropriate. I guess you say appropriate for Zoe to attend Johannesburg. I mean, that's my opinion, and we argued about it for probably about an hour.
All right, well, if that was your agreement, if you want to change your agreement down the road, you'd have to file a motion to change that agreement.
Okay.
So man, you're requesting that the two of you go to a counselor and participate?
Yes.
And sir, you're opposed to that?
Yeah. Yeah, I am. I really am. I feel like we can't even get along, talk on a mediation phone call. I feel it's no, I don't want to do that unless if I'm assigned to.
All right, so it does look like as part of the mediation agreement, there was an agreement to not send rude texts to the other parent. Also things about notification and notifying the other parent, not to disparage the other parent. So have those terms, have those been followed since this mediation agreement?
Yes.
Yes.
All right. Well, I mean, given those agreements that you made, I don't think at this time I'm inclined to order the two of you go to counseling and participate together. If suddenly there are future issues and there are rude text or issues with disparaging each other on social media, then there are certainly options to put the parties into some type of co-parenting counseling, or there's also online co-parenting classes I could order. But you guys did reach an agreement that would hopefully be followed and prevent any future issues. If future issues arise, then those can be addressed. But I think for today's purpose, I'm not going to order that particular matter. I would order that your mediation agreement be adopted and those terms go into place. Again, sir, if you feel that the schooling's not working out, it'd be on you to show why that should be changed in a separate motion. But you've acknowledged that you did participate in the mediation. Looks like it was December 9th. That are the terms that the parties reached. Is that correct, sir?
Yes.
And ma'am, you also agree that you guys participated in mediation on December 9th and reached those terms?
Yes.
Okay. So the court will adopt that mediation agreement. Again, though, I'm not ordering any co-parenting counseling at this time. If there are future issues, either party is free to certainly request that in the future, as well as if you want to change any of the terms of that mediation agreement, you are free to file a motion. You do have to show proper cause and change of circumstances to make any changes, but you're allowed to do so and make that request. Any questions, Ms. Nicholas?
No.
Any questions, Mr. Crowderfield?
No.
All right. Thank you both for appearing here also.
Thank you.
All right, so we were here kind of on a status conference. At one point, we were looking for an evidentiary hearing, and then I think there was some documentation that was needed, and things were adjourned. So, Mr. Saffel, this is your client's motion. Where are we at in the process now?
Well, we have not received any documentation pursuant to the discovery. I think our request would be to reschedule a status conference for, a period of time after Mr. Trevor complies with the discovery request. Maybe that will be never. I don't know what he's going to do, but it should be at least 90 days out to give him time. I know that Mr. Bloomberg at the last hearing indicated that he'd be filing a motion to withdraw. That kind of claim has been made many times. I've never seen one. And I understand this is a limited appearance, so I'm not sure how to deal with that. In any event, the discovery has not been complied with. We'd ask the court adjourn this matter to a later date.
All right, I mean, it's your motion, so I certainly would allow that. Mr. Blumberg, any issue if we just adjourn for another status conference in April?
I don't, and whether I'm still on board or not remains to be seen. I thought we were here today on the plaintiff's motion to modify parenting time. There is very limited parenting time. In fact, it was supervised parenting time ordered by the court, which has been denied by Ms. Atchison. I didn't know if we were going to address that today or not.
Well, I think the only outstanding motion is Ms. Atchison's motion. They're indicating they want this discovery before they have the evidentiary hearing. So I would allow that.
It's clearly they're entitled to discovery. I'm not sure how the discovery requests have anything to do with the motion to modify parenting time.
Well, I mean, again, it's their motion that's outstanding, so if they're not requesting to push this to an evidentiary hearing right now, I will grant that request to adjourn, so we'll reset for a status conference. You'll get a notice for a day in April.
Okay, so
All
just to be clear, the last order of the court still provided supervised parenting time for Mr. Trevor. And so if that's being denied, we file a parenting time complaint?
Yes, if there's any order that's being not followed, that would be the procedure.
Okay, thank you.
Yep.
Thank you, Your Honor.
Thank you. All right, call the matter of Amy Bascom versus Jack Lauber, file number 20-18087 PM. We do have Miss Bascom present. We had a show cause earlier that we pushed off to this time since we had two matters scheduled. This particular hearing is a status hearing on a final custody judgment. And have you guys reached an agreement, signed that agreement, and submitted it?
Yes.
All right, I do see in the court file a consent order regarding custody support and parenting time. It does appear that it is signed by both parties. And ma'am, you're asking that the court enter that consent order?
Correct.
And ma'am, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
So ma'am, Mr. Lauber is not present today, but is it your testimony that he reviewed and signed this consent order?
Yes. I asked him if he had looked over it as he was signing it, and he said yes, he did.
Okay.
He made me sign in front of him and him sign in front of me, so that way we witnessed each other.
All right, so you did witness the signature. Thank you.
Yes.
You asking that the court adopt and enter that order?
Yes.
Looks like it grants you sole legal and sole physical custody. Is that correct?
Correct.
And it looks like his parenting time is going to be currently suspended. Is that correct?
Correct.
It looks like you have some provisions about how his parenting time would restart. You're asking the court to adopt those terms as well?
Yes.
Do you believe this agreement is in the best interest of your child?
Absolutely.
Given that, the court would recommend that the consent order be entered and signed. Looks like the front of the court has signed it and approved it. She would need to come and get this though and take it to the clerk's office, or will we do that?
She would have to take it to the clerk's office.
It looks like this one's still a Judge Hunter case, so ma'am, you do need to come to the office, pick this document up, and then take it to the clerk's office downtown to get the judge's signature. Do you have any questions regarding that?
I do not. Is it, well, actually, yes, I have one. Is it going to be ready possibly tomorrow?
Yes.
Okay, awesome. I can be there tomorrow.
Okay. And then I want to look at the support provision in this. All right, so it's referred for a new recommendation based on 0 overnights. So that'll be done also. Current order did grant some overnights for Mr. Lauber, so there will be a new recommendation prepared. So in front of the court as to the show cause, do you think an adjournment would make sense?
I think so, given that we have report of new employment, just to see how that goes as far as income withholding order.
Okay. Ma'am, is there anything you want to say about the support show cause?
I'm a little frustrated that he didn't show up, but he sent me a message a couple days ago said that he looked at his check and he claims that it has been taken out of his check. I have not, I've been watching the child support website. I have not seen anything pop up. I have not received any notification that a payment has been made. Yeah.
Do you know, in front of the court, if he's got a new job and if there's a withholding order?
I did initiate an income withholding order. We have
Okay.
not received any money from it yet, but that can sometimes take a little bit of time,
Alright.
so.
All right, so certainly there is sometimes that lag of time, so yeah, we'll prepare a new support rec and maybe set a new date for the show cause on March 11th.
Okay.
And if we're in a point where it is collecting, then that date would be removed, but we'll make sure that it's collecting and ongoing and still happening. And then, so if not, we can address that with him on March 11th. Any
Okay.
questions, Matt?
Nope.
All right, thank you for appearing twice today. You're all set.
Thank you.
This is a hearing to address a child support recommendation. Front of the court, any information you wish to provide?
Yes, it was set before your honor today, with the recommendation potentially indicating either parent is recommended to carry insurance. I've had extensive conversations with both parties and have received information from SSI that the child receives medical through that and it's a lifelong diagnosis, so he would always have insurance for himself. So this would be in regards to seeing if that would be appropriate for the uniform support order.
Okay, thank you. Ms. Doobie, anything that you'd like to say?
No.
Is it correct that the child gets insurance due to a social security matter, disability matter?
Yeah. Yep, he gets it no matter what me and his father make because of his long-term disability.
So are you okay if the court does not order either party to provide that medical insurance since that insurance already exists?
I do, yep.
All right. Mr. Jester, anything that you'd like to say?
No, sir.
Are you also in agreement then that the court not order anyone to provide insurance since the insurance is already provided?
Absolutely.
Okay. All right, so given that information, I do believe that is appropriate and makes sense. The child does have insurance through that social security disability matter. So the court would order that neither party has to provide the medical insurance for the child, given that coverage, if needed, a deviation or a change to the order can be made. Are the court any questions?
Nope.
Just requesting if either parties had any concerns or issues with the support recommendation, or if that potentially would be addressed today as well.
All right. Have the two of you received that support recommendation?
Yes.
Yes.
Okay. Is there anything you wish to say about it, Ms. Doobie?
No.
Mr. Jester?
No.
And it looks like it orders Mr. Jester to make a payment. Is that correct, sir?
Yes, sir.
Okay. Do you understand that obligation?
Yes, sir.
All right. All right. Thank you, and thank you for appearing.
Thank you.
Mr. Locker, this is your motion regarding support. Is that correct?
Yes, sir.
And what are you looking to change?
Just the amount I pay. I mean, as stated in there, I wasn't in my right state of mind, never filled in the paperwork. And so they went off where I was making like 70% more than I'm making now.
All right. So you have a current job,
Yes, sir.
working full-time?
Yes, sir.
You're asking that we recalculate based on that employment?
Yes, sir. Yes, Your Honor.
Ms. Lorenzo, anything that you wish to say regarding that request?
No,
Do you have any objection to his request?
I do not.
Okay. All right, so given that, we will prepare a new calculation. If there are any changes in the amount, it would go back to the date that he filed his motion. Sir, have you already supplied your income information?
I dropped it off to, I can't remember her name, our caseworker, Tara. I dropped it off to her quite a while ago. I'll probably have to submit some more pay stubs is what I'm guessing.
All right, yeah, so why don't you provide all that additional information in front of the court? Do you need anything from Ms. Dorenzi, or is that you've got everything you need?
Unless there's been any changes with her employment, I think I'm good with what I have for her.
Ma'am, have you had any recent changes in your employment?
No, there has been no changes.
All right, so Mr. Locker, you need to provide that updated information. I would say within 14 days, so that new recommendation can be prepared.
All right. Thank you, sir.
Anything else, Mr. Locker?
No, sir.
All right, thank you both for appearing. You're all set.
Thank you.
Thanks.
We're here today kind of on a status conference. Do the parties have an agreement on the custody and parenting time?
We do, Your Honor. The parties mediated back on December 10th regarding all issues related to the divorce, and they reached an agreement regarding custody and parenting time of the minor child in this matter. I'm not sure if the mediation status report along with the agreement made it to the court's FOC file. If not, I could simply read in the custody and parenting time provisions to which the parties have agreed, and then the court could take testimony from there.
You guys have a date in front of the judge coming up, don't you?
January 23rd, I believe. It's a couple Fridays from now. We have a pro-con set, yes.
All right. Well, I don't see the need for you guys to run through the testimony twice.
Okay.
You can just do that. Don't you agree? You can just do that with the judge then on the 23rd?
I think that would be appropriate.
Okay.
That's fine with us.
Okay. All right. So then from this court's perspective in front of me, the matter is resolved. Obviously, if things go haywire before the 23rd, the parties can then seek a hearing, but it sounds like there is an agreement in place. Anything else, counsel?
I did have one question, Your Honor. I understand Mr. Hilt hasn't attended the SMILE program yet, and I know we have a final hearing scheduled. And I believe the next SMILE class would probably be the 1st of February or very early on. And I know that the court would want that prior to entering the final judgment. And I do know that there are other circuits, for example, the 13th with Leelanau, Grand Traverse, and Antrim that has the SMILE on demand along with a questionnaire. I'm just wondering if it would be possible for Mr. Hilt to attend that or do something through the front of the court to ensure he attends the SMILE course and gets that completed prior to entry of the judgment on this matter. That way we can avoid any delays.
I don't think I can make that decision.
Okay.
As referee, it'll be up to the judge.
Okay, perfect. Thank you, Ron.
Thank you.
Take care.
Thank you, Your Honor.
Thank you. We were set for an evidentiary hearing today. I did see the parties then requested to do this via Zoom due to an agreement they were reaching. So Ms. Kerr, what would you like to say?
The parties wish to opt out of friend of the court services. There's no motion filed yet, but I could take testimony in support of that this morning if the court is so inclined. They have a couple things that need to get taken care of. I'm not sure if the child is already on dad's insurance, but if she isn't, she will be soon. And I don't know if there's an arrearage right now.
Yeah, well, let's adjourn out a little bit and let those things happen, as well as they can file that opt-out paperwork. How much time do you think you need, Ms. Kerr?
I guess I would ask Carly and Jim that, like, do you think you're going to be able to get this taken care of in a couple of weeks, or do you need a month?
I think a couple of weeks would be plenty.
Jim, do you agree? You're on mute. He's mute. You're muted. Can't hear you. Just nod your head if you agree. Okay.
Yeah. So yeah, the child's already been added to the health insurance, but yeah, a couple of weeks should be more than sufficient.
Okay.
All right.
So what's your next date, Your Honor?
Well, I've got a date on January 28th, but I maybe we'll shoot for February 4th. So that would be 3 weeks just to have that extra buffer. And so the court, I'm assuming, has time to slip you in. It would just be a quick Zoom 15-minute hearing. So we're going to shoot for February 4th, but I can't promise that that's available at this time. I don't do the schedule scheduling for that portion. but
Your
I'm gonna
Honor.
ask. Yes,
February 11th would work better.
okay. Do you know what time roughly?
Yes, at 10:45.
All right, so
Is this-
February 11th
Can we
at
do Zoom for
10:45.
that? Can we do Zoom?
You can do Zoom. Yes.
Okay.
So those are by Zoom. So Ms. Kerr, had them review and sign and file that opt-out paperwork, and we'll address everything that day.
Is there an arrears showing on the front of the court system right now?
Don't have the caseworker with me,
Okay.
but certainly your client is free to reach out and have that conversation.
We can do that.
All right.
Same
All right,
Zoom,
anything else,
Your
Ms.
Honor?
Kerr?
Is it the same Zoom
It is, yes.
today? All right.
Yes.
Jim, do you have any questions before we?
No, I'm good.
Okay. Thank you so much.
All right, thank you everyone for appearing. You're all set. We'll see you back here February 11th.
Thank you.
Thank you very much. Bye.
Friend of the court, what is the status of this matter?
The plaintiff's support obligation is $592. Current balance on the account is $2,672. A uniform child support order entered in May of 2025 after the plaintiff's release from incarceration. A payment of $3,000 was received this month on behalf of the plaintiff. But that is the only payment that's been received since the order entered. Given the recent payment, I would just request to potentially adjourn to monitor additional payments.
Thank you. Ms. Slick, anything you'd like to say?
No, sir.
All right, well, given that there was a substantial payment made, I will adjourn it out to see if payments continue. I will adjourn to March 4th. Thank you for appearing, ma'am. You're all set.
Thank you.
The defendant's monthly support obligation is $42. $729 is owed in overdue support. There's only been one payment received since the order entered in the amount of $2 in August of 2025. It was brought to my attention today by a friend of the court staff member that she was planning to make a payment. She initially appeared with a credit card, but chose to leave and grab funds. So I'm unsure if she's made a payment or not yet.
All right, thank you. All right, ma'am, what would you like to say?
I am here right now in front of the court and I just paid $650, I believe it was. Yep, $650.
Okay. Are you going to be able to keep up then moving forward with your monthly amount?
Yes, but I have a question because Zach hasn't paid. He left for 3 months back in May for Tennessee and claimed he couldn't pay child support anymore. I don't know why. He just took off, and I actually didn't even know he took off. I had to find out through family that he had left the state, and through a friend of the court that he wasn't able to pay anymore. Now he's working again and stuff, and I haven't seen a payment of or a child support payment since May. And even when he took off for 3 months and I was doing most of the work, I didn't see a dime. And I'm paying him still. And now I'm so backed up in, this way I just had to put $650 down, and he hasn't paid a dime.
Does he have an old obligation that he owes money on?
He was supposed to. I used to get $140 a month, between $120 and $140 a month I would get. But since he left and said he couldn't pay anymore to Tennessee, they nobody has said anything or did anything, and he hasn't paid since May. It's like he never really filled out saying he was working again. And I know he's working. He's got a very good job.
All right, in front of the court, do you have any information you can provide?
Yes, Your Honor, a temporary uniform child support entered in May of 2025 that did change the payers. A new recommendation was to be initiated once friend of the court was not notified or discovered a change in the plaintiff's income. While prepping for this show cause today, I did receive Michigan quarterly wages that were reported. So friend of the court did initiate a short review and the forms were generated and mailed out. by Central on January 12th. So a new recommendation is in the process regarding that. If she has additional information, she can call and provide whatever that is to our office.
All right, ma'am. So front of the court was aware that he is back to work, so there is going to be a new support recommendation is going to be prepared that's going to address his new income.
Yeah, because it's been since May, and like I said, now I'm backed up. So if somebody could look into that, I mean, I asked when I came in to
All right,
front of
ma'am.
the
So we
court.
are there is a new recommendation being prepared.
Thank you.
Given the sum that you paid today, which almost takes care of the amount, I'm not going to adjourn this. We'll just monitor it. If you fall back behind, then certainly you'd be back before me, but perhaps there will be a change with the new recommendation. But until there is a change, obviously you still are required to make that $42 monthly payment and get
Right.
yourself caught up. Okay?
Yeah, and I just got my receipt for the $650 that I did pay today in cash.
All right.
So
Thank you. You're all set. Yeah.
all right, thank you so much. And soon when I change my receipt, I just give it, or my receipt, my address, I just give it to the front of the court, correct?
You should do that in writing while she's here.
Yes, you need to let front of the court know. You can certainly do that today if you have that change now, but if it's later, make sure you come back and provide that information.
Okay, yeah, just because I don't want to miss anything, like, paperwork or anything. All right, thank you so much. And what judge is this? I'm so sorry. I can't see anything. I can only hear me speaking.
This is referee legal. You're all set for today. Thank you.
Oh, okay, all right. Thank you, Mr. Legal. Have a great day.